people's champion. Our mission is love, our vision is love. Jamaicans, for justice, the people's champion, champion. Justice, justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Justice, justice for all. Justice under the law. Justice, the people demand. Right to life and security. Oh, what a joy. Oh, what a peace. How great this country could be. Respecting your rights, respecting human rights. What a wonderful nation this could be. Out of many we are one in a Jamaica. Jamaicans, for justice, the people's champion, champion. Justice, justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Out of many we are one in a Jamaica. Make it a better place for the boys and girls. Created equal by the creator. For equal rights and opportunities. No to unlawful detention and police brutality.
Welcome to Let's Start Justice with JFJ's team. My name is Michael Jackson, Executive Director of JFJ.
And I'm Jade Williams, Policy and Advocacy Specialist at JFJ.
Now, Jade, we're going to be discussing an important topic for this week. For those who are paying attention to what is happening in the media cycle, you should know by now that the country is undergoing a constitutional reform process. And with that, it means that there are discussions happening. You will see where the opposition leader is indicating that he's not signing off on some documents. We're going to be probing that issue with the Most Honorable Bruce Golding, who is a former Prime Minister of Jamaica. We were due to be joined by the Most Honorable PJ Patterson, also former Prime Minister of Jamaica, but due to some scheduling issues and some misunderstanding, we will just have Mr. Golding, who is quite familiar with the issues, and I know who would be leading us through some very thoughtful discussions that we will be having. But we have some housekeeping matters before we go to Mr. Golding, and Jade, you will lead us through that.
Okay, thank you so much, Michael. So first things first, I'm going to do our Did You Know and or trivia question for this week. Or Did You Know for this week is going to talk about something that is relevant to our discussion today. We're talking a little bit about the Constitution, and we're asking, did you know about Section 48 to 51, which talks about amending the Constitution? And in order to amend our Constitution, we have three tiers on which amendment takes place. We have our ordinary amendment, which is just passed by a majority vote in the Parliament. So whatever bill it is that is going to amend the Constitution, a simple vote of majority in the Parliament will allow it to pass. For ordinarily entrenched provisions, though, there is this need for a 2/3 majority vote for both houses, and then the bill may not be accepted unless it spends 6 months in the House of Representatives. So that is 3 months after it is tabled in its introductory period and 3 months between the debate and its passing. And then finally, we have our deeply entrenched or specially entrenched provisions that have all the same requirements as our ordinarily entrenched provisions, but also the amendment will be subjected to a referendum. And that means us as the public will be able to vote on the issue. And it requires a majority vote from the public in order for it to pass.
And just to add a little bit of a trivia to that, Jade and listeners, there is a way to get around the opposition, but it is a high task that is perhaps not even achievable as much. But for the ordinarily entrenched provisions, if you do not have the opposition playing ball and agreeing, then you can have 3/5 majority of the citizens having that particular provision being passed. And for the deeply entrenched, and I won't give an example, I almost did, then you need 2/3 of the citizens in that regard to have that being passed. So there is a little way of getting around the opposition playing ball, but again, whether or not it's practical is another conversation to have. And I know Mr. Golding, who is now online, have some views on that, but I will allow you to finish, Jade, your trivia question.
Thank you. Okay, so we also have a trivia question for today, and that is asking, other than changing the head of state, which is one example, what is one other deeply entrenched provision that we have in our constitution? So that last year that we spoke about on the Did You Know? What is one other provision besides changing the head of state that qualifies as that? And you can
Are we
respond to that
double up the
through
question? $2,000 credit this week?
just 1,000 because the original amount was 500. But you can respond to that through our social media pages, or you can send a WhatsApp message to 876-239-7583.
All right, thank you so much. Mr. Golding, our former Prime Minister, are you with us?
Yes, I'm trying to join you.
Okay, good afternoon.
Good afternoon to you too.
Thank you so much for joining us. We certainly appreciate it. Just to start out, for the listeners being aware of what is happening, we know that there was the establishment of a Ministry of Legal and Constitutional Affairs, and they were tasked with building on the efforts of the 1990s with a renewed focus on constitutional reform. And following that, there was a terms of reference that was developed that outlining 3 phases that we will be pursuing as a country. Jade, can you just remind the listeners what those 3 phases entailed?
Yes, I can. So the first phase was to focus on specially entrenched provisions with a particular focus on removing the monarchy, while the other 2 phases would have examined other provisions, including the Charter of Fundamental Rights and Freedoms, and whether or not we would adopt the Caribbean Court of Justice. However, there was no indication that more substantive changes, for example, to electoral reforms, would have been undertaken in the process.
Well, Mr. Golding, I'm not sure if you're aware, JFJ and others, NIA, for example, we have been very vocal in our concerns about how the Constitutional Reform Committee itself was established, which differs a little bit from the 1990s, with how the commission was established then. We were quite vocal about our concerns with the phase process, given some issues are interconnected. And as you're very well aware, sir, you have some people who are saying, I will not be voting a referendum unless I know what the president is going to be looking like. And we've heard from the People's National Party, the parliamentary opposition, that their position at this time, they will not be signing off on the Constitutional Reform Committee if the matter of the CCJ will not be discussed. And just this morning, we heard from the Most Honorable Prime Minister, Andrew Holness. He was speaking on CVM at Sunrise, where he indicated that the JLP's position at this time is that they would be supporting a final court here in Jamaica, and the matter perhaps ought to be put to a referendum. So having said all of that, what is your immediate feedback, before we get into some specific questions?
Well, before I give you an immediate feedback, I think we need to look at the historical context because it is important. Our Constitution was built in a particularly restrictive way. The framers of our Constitution determined that there were certain provisions in the Constitution that they felt were so important to the good order and sustainability of the state that they didn't want any government, no matter how powerful its majority in parliament, to be able to change that. So that they insisted that changes of those sections would require a 2/3 majority in each house of parliament. They went further and they structured the Senate in such a way that no government, even if it won every seat in parliament, no government would be able to secure a 2/3 majority in the Senate, which means basically, practically, that for any change to be made to those critical sections, there has to be consensus between the government and the opposition. Certainly, there has to be at least one opposition member who is prepared to support the government or to support a proposal for change. That is the handiwork of Norman Washington Manley and Donald Burns Sangster, who were the principal architects of the Constitution. So I used to refer to it as belt and braces. It is more like chains and shackles.
Yes.
And those shackles require two keys to unlock them. And as your previous presenter indicated, for certain of those provisions, they require not two keys, but they require three keys, the third being the one held by the people. Now, let me just point out that of the 131 sections in the Constitution, 58 of those require consensus if they are to be changed. 58 sections of our Constitution. And there are another 11 sections that even if there is consensus between the government and the opposition, they still require that third key, the approval of the people. So that in approaching constitutional reform, we have to start out with a clear understanding that there has to be agreement between the government and the opposition. There has to be consensus. Now, that consensus between combative forces, because that is what government and opposition are in a competitive democracy, is not easy. It is not easily achieved around a formal committee table, trying to hammer out issues and trying to reach consensus. It requires a lot of interpersonal relationship, a lot of discussions, a lot of goodwill, a lot of trust, because each side has to be convinced that the other side is not seeking to gain a political advantage. And therefore, while we can set up constitutional reform commissions and committees and so on, if there is not that direct, genuine discussion taking place between both sides, it is unlikely that you're going to achieve the consensus that is a prerequisite to any major change. Now, bear in mind that our first effort at constitutional reform was in the 1970s, when Michael Manley was Prime Minister. But as you may be too young to recall, that was a very polarized period in our history, perhaps the most politically polarized period in our history. And that effort fell victim to the political heat of the day. Another attempt was made in the 1990s, and that was far more successful. Not that we didn't have difficulty. I was a member of the parliamentary committee that reviewed the report of the Constitutional Reform Commission. Not that we didn't have difficulty. There were some tough
I don't
issues.
think you signed that report, Sir Golding.
I didn't sign it because at that time, as president of the NDM, I had issues regarding the question of the executive presidency.
Yes, that's my recollection.
That is a position from which I have since resigned. But what we made significant advances. There were 13 broad issues on which we agreed. There was one issue on which we could not agree. And among the 13 issues on which we agreed, there were 4 that while we agreed broadly, there was disagreement as to how it would be implemented. Among those, of course, was the Charter of Rights, on which there was full agreement. Now, when the commission, the most recent committee was set up, or commission was set up, I had hoped that that commission would basically pick up those issues on which agreement had been arrived at, review them to see whether or not there was any change of position. But if there was not, to check those boxes and say, let's proceed with these, because these were agreed in 1995, and that agreement has been sustained. I got a sense that the committee perhaps felt that the wheel needed to be reinvented to start all over again, and that I think was a mistake. But having said that, what I hoped we would have been able to do was to say, no, let's proceed with those issues on which agreement has been reached and get those implemented. Now, bear in mind, one of the agreements that we had reached in 1995 was the Charter of Rights, and that was implemented in 2010 while I was Prime Minister. And even that was a difficulty because the PNP opposition at the time had said they were not prepared to agree to that implementation, although they had agreed to the Charter of Rights.
Yes.
They were not prepared to support its enactment unless we dealt with the question of the CCJ.
Mr. Golden,
Eventually,
can you hold that thought for me? We have to take the break. Even though we're doing
Sure.
two recording, we still have to take care of business.
sure, I will.
The people's champion. Our mission is love. Our vision is love. Jamaicans, by justice. The people's champion.
Welcome back to Let's Start Justice. We are privileged to have with us former Prime Minister, Most Honorable Mr. Bruce Golding, and we were having a discussion on some of the areas of consensus of the past. Mr. Golding, you were walking us through some of the 4 areas, I believe, the Charter of Fundamental Rights and Freedoms, and please finish out the thought.
Yeah, well, as I said before, we had agreed on 13 important areas of change in the Constitution. And there was one area that we couldn't agree on. That one area had to do with the method of appointment of the Public Service Commission. But there were 13 areas of agreement. But within those 13 areas of agreement, there were 4 areas where, even though we agreed in broad principle, we did not agree on how it would be implemented. And therefore, one of the things that I had hoped was that this new committee would have examined those 4 areas, 4 issues on which, while we had agreed broadly, we had difficulty with how they would be implemented, and see to what extent we could resolve them. Now, I mentioned the Charter of Rights, which was an issue that was fully agreed. And in 2010, I suggested to the opposition, look, there are a number of other issues that we have to sort out, but this is an issue on which both of us agree.
Yes.
Can we proceed with this? Because the question of the rights of the citizens of Jamaica is so important. When you look at the rights that existed before, they were all compromised. The Constitution allowed the government to pass laws that would abrogate those rights if they felt that that was necessary in the interest of public safety and public morality and public order and that kind of thing. And I said to the opposition, let's proceed with this. Now, the opposition then said, no, we're not prepared, even though we agree on those things, we're not prepared to proceed unless you deal with the question of the CCJ. It took discussions between the government and the opposition at Vale Royal, and subsequently direct discussions between myself and Portia Simpson Miller, who was leader of the opposition at the time. And eventually, we both agreed, Portia and myself, okay, let's proceed with this item, since this is an issue that is so important to the people of Jamaica. And that was what enabled us in 2010 to enact the Charter of Rights, which could not have been done without a 2/3 majority in the Senate, which means it could not have been done without the support of the opposition, which means it could not have been done without consensus. I keep coming back to this issue of consensus because there's no significant change that can be made to the Constitution unless there is consensus. And consensus can't just come about by, issuing press releases and so on. We managed to make as much progress as we did in the 1990s. You know why? We had problems at the table,
Yes.
We argued and we quarreled. You know what made the difference? Edward Seaga and David Corr, who were the 2 surviving members of the initial committee in 1962 that drafted the Constitution. They got together quietly without us, behind the scenes, sat down, had a cup of coffee, and they discussed these things, and they were able to resolve a lot of these difficult issues so that we were able to move forward. I mentioned that
Mr.
because
Golding, that we're not having that type of connection now and
I
consensus.
can't say because I'm not there. But
Hmm.
what I can say is that were it not for the kind of relationship that existed and the kind of exchanges that were possible between Edward Seaga and David Corr back in the 1990s, we would not have made the progress that we made. And I'm therefore saying that to say that in going forward, that kind of, for want of a better word, fluidity, that kind of trust, where people who feel comfortable with each other are prepared to sit down and say, hey, for example, when we started out that discussion in the 1990s, the PNP, like myself at that time, were in favor of an executive president. And it was Seaga and Corr meeting quietly. Seaga was totally opposed to an executive president. And it was the two of them meeting quietly that eventually got David Corr to say, okay, we will pull that back. We will not insist on that. I keep making the point that unless you have that kind of conversation, comfortable conversation, where people feel that, look, we can talk, we can disagree, but at the end of the day, we're not going to get up here until we get to some kind of agreement. That
Yes.
that is a critical part of the process.
But how do you balance that with the need for consultation with the people? Because while I can appreciate the legislative process that requires consensus, I think sometimes in this discussion, we are negating the importance of the people being consulted on things that they are expected to vote on. And
I
that
agree.
my
I
challenge.
agree entirely with you. But at the same time, the people must take some responsibility. It's disappointing to me, for example, to note that when the Constitutional Reform Commission of the 1990s, chaired originally by Mr. Justice James Carr and subsequently by the Honorable Lloyd Barnett, they embarked on an island-wide consultation. They went to every parish.
Yes.
They held town hall meetings. The attendance at those town hall meetings was pathetic.
Yes.
People just were not interested. And they invited public submissions. The number of public submissions that they received was less than the number of public submissions that were made when the initial committee of 1962 invited submission. And that committee was on fast rapid. That committee put together the Constitution in a matter of a couple of months. And in that couple of months, they invited submissions and they received almost twice as many submissions from the public as the James Carr stroke Lloyd Barnett Commission received in the 1990s. So the public, I'm not being disparaging, but if you give the public the opportunity and you put together a public education program to encourage them to become involved, and they don't become involved, you can't blame the government, whether it is the government of the 1970s or the government of the 1990s or the government of the 2020s. The public needs to assume some responsibility, and JFJ has a critical role to play in trying to stimulate that.
It's something that, we've been having that conversation, and can I tell you that we've developed booklets and so on, and public education materials. We're doing videos. The question though, even if we wanted to have more public consultation done, what more is expected from the Ministry of Legal and Constitutional Affairs? Because I hear you, that from our perspective, we have taken the position that, look, public consultation is one thing, but we have to start with public education. And I think with the greatest of respect to those who have embarked on this process, I think enough is not being done while we also hold the public to account.
I can't dispute what you're saying, but I think we have to address frontally, bluntly,
Yes.
this issue. That if you say to citizens, look, we're having a community meeting at the community center to discuss constitutional reform. This is important to you because this affects your rights, it affects your future. And if you have people who are not interested in being part of that, unless it is going to tell them when they can get a work, or when they can get a bed, or when they can get some fertilizer. If that is the attitude of the people, then the people have to accept that responsibility. We can't accept that responsibility for them. JFJ can't accept that responsibility for them. They have to step forward.
Yes. Yes.
You know, as you spoke about the things that they're concerned about, you know, I think part of that is out of necessity, you know, people think I have to focus on my bread and butter issues. I mean, how do we accurately marry that this major issue of constitutional reform is related to their bread and butter issues? Because I think if we're better able to do that, we'd have a greater interest in the matter.
Well, I think more needs to be done in terms of public education, but ultimately, we must not excuse people if they choose not to accept their responsibilities.
Yes.
The government mustn't do that. JFJ mustn't do that. JFJ has been doing a sterling job in terms of trying to, you know, get people to understand, sensitize people that, look, your life is more than just the bread and butter. Your life is your future. But ultimately, they have to accept some responsibility for themselves. And too many Jamaicans, too many of us, feel that, well, they must leave that to some higher ups. And when they don't like what is happening, them cuss the higher ups. Well, they must take some responsibility. They must get involved. I mean, when I was Prime Minister, you know, some of the most challenging periods, and I want to say enjoyable periods, was when I got into exchanges with people, particularly young people. And they bowled some questions at me that almost floored me. And I had to just reach deep into my brain to say, now, how do I respond to that? But there were not enough of those.
Yes.
And that's something that we need to encourage.
Yes. You know, thank you so much. I want us to discuss a few more things because we've been doing town hall meetings at JFJ, and some of the discussions so far, what would the president look like? Because, you know, I hear your position of the past, and JFJ does not support an executive president because sometimes you're swapping out one thing for another without fixing the underlying issues. But how do we break this down to the people? And I wanted to hear your perspective on the president, what we are proposing. And the other thing I wanted to touch on a little bit is the matter of the CCJ. But I
Can we
think
deal with the president first?
yes,
And
we
then
have
come
a
to
minute
that?
before we have to go to the break, but we can
Sure.
start, President.
You want to start now?
Yes, please.
Jamaica has created a hybrid, a very impressive hybrid in terms of our head of state. Forget about the Queen Elizabeth and King Charles. Our head of state is the Governor General. But what we have done over a period of years, starting back in the late 1970s, is that we have vested in the Governor General, who previously was just a ceremonial office holder. We have vested in him certain quasi-executive powers. For example, he appoints the independent members of the Electoral Commission. He appoints the members of the Broadcasting Commission. He has to consult with the Prime Minister. He has to consult with the leader of the opposition. But after he has consulted with them, it is his decision to make. Now, I don't know of any other country Commonwealth, certainly Commonwealth countries in the world where that exists. And it has worked.
Yes.
And Jamaica is fortunate in that over the years, we have had from Glasspool to Howard Cook, to Kenneth Hall, to Patrick Allen. We have had governors general who understand the weight of this responsibility, and they have discharged it well.
As I thought, Mr. Golding, I want us to pick up on some of those reserved powers that you're outlining and some other matters with the presidency. We take the break.
The people's champion. Our mission is love. Our vision is love. Jamaicans for justice. The people's champion.
Welcome back to Let's Start Justice. We are having some good historical information. Context is important, but also for us, you know, Mr. Golding was walking us through and it's a pet peeve of mine, Mr. Golding, when we use the word ceremonial president. I think we do a disservice to some of those quasi executive powers that you were outlining, and there are others. If you could just finish your thought on the model that we have that we are looking to codify, if you will, with the new non-executive president that is being proposed.
Well, up to 1979, the Governor General position was largely ceremonial. I would think almost entirely ceremonial. With the exception, the only area that he had jurisdiction was in the question of granting pardons.
Yes.
He had the exclusive authority based on the advice of his Privy Council, the local Privy Council, to grant pardons. But starting in 1979 with the Electoral Advisory Committee and the appointment of the independent members, he assumed quasi-executive powers. And those have been enhanced and added to since then. And it has worked well. It has worked well. But it's working well depends, of course, on having a Governor General in whom both sides can have confidence, in whom the public can have confidence. And I think so far, all of the Governors General that we have had since that time have commanded that confidence. And that is something that has to continue, which is why the issue of how the president in a republic would be appointed becomes so important. And that is an issue, while we agree broadly on Republican status, there has been a disagreement as to how the president would be appointed. Back in the 1990s, the government then insisted that they should be appointed by both houses of parliament, nominated by the Prime Minister after consultation with the leader of the opposition, but subject to approval by Parliament, both houses of Parliament voting together with a 2/3 majority. The opposition then insisted that no, it should be appointed by both houses of Parliament voting separately, so that the 2/3 trigger
Can be there as a safeguard.
would come in. And that remains my own view as to how it should proceed. So that position has served us well. And if we craft the president in that kind of framework, then I think that we'll be in a good position going forward.
Yes. Thanks for that. Because, you know, we have a position here at JFJ actually to broaden the scope a little bit to a special electoral college, to perhaps include councillors. It's something that we thought about. But outside of that particular recommendation, we don't support a direct election because, one, the symbol of unity of the president, given some of the reserved powers. I am not sure your thought on a directly elected.
Agree entirely with you. You don't want a president to have to go on campaign. On which platform would he stand?
Exactly, yes.
You know?
But how do we explain that to the people? Because it's a sticking point for some voting in a referendum, you know.
It's not difficult to explain. If you want a president who is not beholden to the JLP or the PNP, what you want him to do, to go campaign on an independent platform, the JLP and the PNP would swamp him.
Yes.
I don't think it's hard to explain. And the fact that it has worked so well with the Governor General for the last, what is it, over 40 years. You know, if it ain't broken, don't fix it.
Yes, 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 yes.
I wanted to go on to the question of the CCJ, which
The
you raised.
CCJ. So that's another sticking point. That is now what is called a stalemate in this
Yeah.
conversation.
Yeah.
If you could explain for the listeners the issues then and what you would recommend now going forward.
Regarding the CCJ?
CJ versus Privy Council.
Well, going back, the PNP opposition has always been in favor of the CCJ, and they tried to implement it back in the 1990s.
Yes.
And it was challenged by the Bar Association, by the opposition, taken to the
Jamaicans for Justice was a party to that
and
challenge.
Jamaicans for Justice, yeah.
Yes.
And the Privy Council ruled that the way in which it was done was contrary to the Constitution. That's history. Let me give you my perspective. There are 4 issues that I think need to be considered. One is the question of sovereignty,
Yes.
which is a symbolic issue. I say symbolic because in truth and in fact, neither the Queen who died nor the King who now reigns, neither of them has interfered with our business, right? So that their position of head of state has not caused us any distress. But symbolically, it is important. You can't claim to be an independent country if your head of state is not a citizen of your country. You know, not only him don't born you, him never live you.
Yes, yes.
You know what I mean? So that is important. But I will say to you that as important as that is less important to me than the other 3 issues that I want to raise.
Yes.
Issue number 2, question of access. If I want to take a case to the Privy Council, let us say that I have exhausted my local courts, Court of Appeal turned me down. I want to go to the Privy Council because I feel that I have not got the justice that I want. If I want to go to the United Kingdom to be there when the Court of Appeal is hearing the matter, I have to apply for a visa. I can be turned down. My attorney has to apply for a visa. And he too can be turned down. Even if he tells them he's going to represent me, he can be, for example, he can be turned down if he, on a previous visit, overstayed his time without good reason. Or even if he presents good reason, if he overstayed his time by more than 14 days. So, in other words, I would not have access to my final court.
Yes.
That's a major concern. The third issue has to do with the quality of the justice that you are getting. Now, if you are to dispense with the Privy Council and you are to go to the CCJ, you need an assurance that the quality of the justice, the quality of the jurisprudence from the CCJ is going to be as good, if not better.
Exactly.
Now, that requires assessment, no? I have hitched onto the line of Edward Seaga back in 2005, I believe it was, or 2006. Edward Seaga said, look, this is a new court. And this is after we had resolved a lot of problems, regarding how the judges would be appointed, regarding their independence, regarding their security of tenure, regarding this financing of the court to ensure that it could be sustained. After we had resolved all of those, because those were major problems.
Yes.
But after we had resolved those, he said, look, this is a brand new court. We don't know how it's going to work. Let's watch it for 10 years. And at the end of 10 years, let us review its operation. Let us look at its decision. And let us come to a decision as whether we are compatible with the quality of the justice that it is dispensing. Now, the court was set up in 2005, which means that the court is now 19 years old. Mr. Seaga had said 10 years. We have not done that review, as far as I'm aware. There has been no government-directed, opposition-involved review to say, no, let's look at this. I looked at the decisions of the court, not all of them, but most of them, up to 2020. I haven't looked at any since. And I was quite impressed with the quality of the decisions that it had delivered. Now, that review, which Mr. Seaga suggested, needs to be undertaken. And we need to then have a robust discussion that would involve JFJ and a lot of other stakeholders to say whether or not, put it this way, the CCJ can make mistakes, The Privy Council has made mistakes.
It's just that they're final. It's not that they're perfect.
Yeah, you remember what Justice Robert Jackson said?
Yes.
We are not final because we are infallible. We are infallible only because we are final. So let's look at the decision. Let us do a serious review. Let us get some of our best lawyers to jump in and say, no, look, we feel that they made a mistake here, but at the same time, they created some impressive new jurisprudential breakthroughs here. And then let that inform us as to whether or not we'll be comfortable with it. So that's my third issue. The fourth issue, which I consider to be as important as the others, is the question of sustainability. Now, in relation to the CCJ, we contributed $25 million to it.
US
That
27
went into a fund.
exact, yes.
I'm
US
sorry?
27 out of the 100 mil.
Whatever it was. That
Yes.
went into a fund. That fund suffered when we had the global meltdown.
Yes.
But I remember I was on a flight from Port of Spain to Kingston, and the president of the court, Justice Byron, was on the flight with me. And I asked him, I said, how are we now in terms of the funding? And he said, we suffered some blows, but we have recovered. I looked at a financial statement about 2 years after that, and it seems to me that we have in fact recovered. So the question of funding the court going forward seems to be okay.
The people's champion. Our mission is love. Our vision is love. Jamaicans, for justice. The people's champion.
Now, on the question of sustainability, you know what worries me, Jade? Michael, what worries me is that our ability to access the Privy Council is rooted in the Judicial Committee Act of 1833 in Britain.
Yes.
And rooted in Section 21 of that act. Now, a few years ago, when Lord Phillips was president of the court, he signaled to us that, look, the court is getting weary of these cases from the Commonwealth. And we would like you to go make your own arrangements because we can't deal with your cases anymore. That has since been rebutted by his successors,
Oh,
who have
yes.
said that they are prepared to receive appeals from Jamaica and other Commonwealth countries for as long as we want them to do. But what concerns me is that this is not a judicial decision, you know. This is a political decision.
Yes, yes.
It is the British government and the British Parliament that can decide whether or not we can still access the Judicial Committee of the Privy Council. And you might recall,
Yes,
that during the time of Prime Minister David Cameron, there were some voices in the Conservative Party, which formed the government at the time, which suggested that for cost implications, because it is costing them, they were thinking of telling us no more cases. I'm worried about that. I'm worried that the British Parliament could tomorrow amend the Judicial Commission Act of 1833, amend Section 21 to say no more cases from Commonwealth countries.
yes.
I don't want my final court to be hanging on that kind of, that slender.
Yes, and you know, Mr. Golding, people may be listening and say they won't take that extreme position. But we've seen the merit rule that was recently pushed through to say that decisions can be taken without consultation that will even impact our constitution, which is a challenge for us here at JFJ as well. So I am not sure where you stand at this point that you could offer some guidance, because we've heard from our Prime Minister this morning at CVM at sunrise that we should go perhaps still thinking about a final court here in Jamaica. And I think you had articulated that view in the past. What would you offer as comment on that particular position now?
That is an option. That is an option. I believe that we have the quality of judges here. The judiciary here, there's only one judge that I can recall that has ever been legally compromised. We have the quality of judges here. I believe that we could form our own court of appeal, our own final court.
Yes.
The question that we'd have to determine is whether or not we want to incur that cost. If we have access to a court, which is an itinerant court, which could very well decide that it is going to sit in Jamaica for the months of June and July to deal with all the cases that emanate from Jamaica. That's a question that we would need to address. But I do believe that we cannot be comfortable with a critical part of our constitutional structure being at the whims and fancies of British legislators who may just want, you know, if you look at what is happening in America now and what is happening in other parts of the world, politics have gone crazy.
Yes, yes.
And therefore, the kind of assurance that I may have had 20 years ago or 30 years ago about the stability of our international customs and norms, I no longer have that.
Mm-hmm.
And, you know, you could very well end up after the next elections in Britain with some Marjorie Taylor Greene who just decide to hell with Jamaica and all them black people country. We don't want them. We don't want to have to spend money to deal with them.
Yes, so Jade perking up, Mr. Golding.
What's that?
I'm asking if you've seen Jade perking up when you made that comment.
Yeah, I don't want to be exposed to that.
Yes, yes.
I don't want to find a situation where somebody has exhausted the Court of Appeal here, but he has nowhere else to go because the British Parliament has just locked. What do we do at that stage? Do we run down to Trinidad and say, well, here we're ready to come now?
And we don't have the infrastructure just to start now with our final court. Because
Well, I don't know. Maybe we could provide the infrastructure. I don't know. I mean, that requires a new discussion as to whether or not we want to duplicate what is going on at the CCJ. I mean,
Yes.
there's an argument that I've heard. I heard the minister recently that saying if we're talking about repatriating our sovereignty, how can you then be talking about re-exporting it to Port of Spain? Now, that's an argument, and we can't dismiss that. But ultimately, I think we have to make a determination as to what we think would be in the best interest of the people of Jamaica in terms of getting justice.
Yes.
Now, if we can find the billions of dollars that it would require to set up our own final court, I don't know, 5 members, 7 members, provide them with the facilities. That's an option that I canvassed when I was Prime Minister. I asked a committee to look at it. Some people are opposed to it. I think more based on their commitment to CCJ. I don't believe that is enough of a reason to dismiss it. It is something that we need to look at seriously.
Yes.
But I am uncomfortable with the possibility that I may need to go to the Privy Council, and neither me nor my lawyer can get a visa. That worries me.
Yes.
Worries me badly.
I agree. And just for clarity.
When the UK people here turn you down, they tell you that they're not obliged to give you no reason. Well, my reason is that I need to go there because I have an appeal and I am entitled. That is my final court. Well, sorry, we can't help you. I'm not in that, Michael.
Yes. And I was saying for clarity for our listeners, JFJ is in support of the CCJ. The question for us at this point, only 2 options should be on the table. A final court here and CCJ. Based on
maybe that's where you need to stimulate some discussion.
Yes. We're up on time, but I want to find out from you if there's any other sticking point that you think ought to be in the discussion here about constitutional reform. I know Section 49 is one.
There's one other point.
Yes.
And that has to do with Section 49. Remember, I spoke about chains and shackles. I think Norman Manley and Donald Sangster went too far, because Section 49 is a section that deals with how you can amend the Constitution. But we've run into a problem where, for example, those sections that require only a 2/3 majority to amend, you cannot introduce any new section into that without a referendum. So we have run into the problem where we would like to entrench the Electoral Commission of Jamaica so that no future government can mess with it. But we can't entrench it because we'd have to amend 49. And in order to amend 49, you have to go through a referendum. I believe that we should lift out, I think it's subsection 2, make that its own subsection, its own section in the Constitution, so that you can very well provide that you can't remove anything that is in there, but you should be allowed to introduce new section, so that if you want to entrench the Electoral Commission, if you want to entrench the political ombudsman, you don't have to go to a referendum for that. You can, by a 2/3 majority, do that. And that's an issue that I think needs to be taken up. I brought it to the attention of the committee.
And I hope you'll be pleased to recognize and know that it was a statement that you made in the past that led JFJ to make a recommendation similarly.
Well, I'm happy to hear that.
Let's hope that they take it up. So thank you so much. We appreciate your time and being here with us. And I hope to have some more discussions with you on some other matters.
Sure, I'm available. If my grandchildren allow.
But I'm not here, well, they're at school, though. Maybe that's why we're not hearing them in the background. All right, thank you so much. That is our 8th Prime Minister, Mr. Golding.
I believe so.
Yes. former Prime Minister of Jamaica, Mr. Bruce Golding, most honorable. Thank you again, and we appreciate your presence.
Well, thank you so much. God bless you all.
Take care. All right, so to continue the discussion, we have been hosting some town hall meetings, Jade, but how you feel about what was discussed just now and what you think we need to push in the town halls?
Boy, my brain feel big right now, Miss Jackson.
Big, what's good with information?
Yes, it feels quite big right now. But I think what has stood out to me quite distinctly is the pushing the narrative that we shouldn't be discussing the Privy Council at all. I think that considering that it's such a point of contention right now, that it's a poignant thing for us to be bringing out to the public, that if we're really considering independence, we need to either be looking regionally or locally. We cannot be looking internationally. I think that's an important point in the discussion.
Yes. Or if we're going locally, personally, I'm not averse. I need to discuss with the board before I have an official position on it. So this is my personal view. And I try not to have personal views because I know my personal views cannot be divorced fully from JFJ's. But I think if we're going to go locally, it has to be based on a timeline. We're going to right now go to CCJ and say, establish a timeline for our local courts to be, or for a final court to be local. And in that regard, we can then entrench our final court, because that's a conversation being had, a debate, whether or not we should be entrenching what is still going to be a foreign court with the CCJ. But when you have issues, for example, not enough stenographers and some resource constraints here, I don't think we're ready for the local courts here. But I think we should say maybe 10, 15, 20 years from now, we will have our final court here, but let's go to CCJ for the time being, given that the CCJ is already, up and running. And, and I urge people, you have the financial statements in on the CCJ's website. They can go and look how your money, the $27 million from Jamaica, how that going. There was a question, Jay, that somebody asked me on Twitter. Whether or not, and we need to speak quickly, whether or not we have control of CCJ. And I said, collective control is there, because you do not have one single country having control. It's a regional court. So you have collective control because you have the trust fund where you have invested and accountability must be maintained. That's for the sustainability. We've had the court itself. Currently, we have the Honorable Mr. Justice Winston Anderson, born in St. Anne, who is one of the sitting judge. And finally, you have the commission. From its inception, you had Dr. Lloyd Barnett being a part, and the commission is there to ensure that all your higher fire discipline judges is properly maintained. So yes, we have some influence. So I want to dispel of this myth that somehow we're swapping one that we have no control over to another. That's not the case. But it's more, and on May 31, we will be at Jamaica College with some very good speakers talking some more on this particular issue. But Jade, what is the answer to your question that you asked?
Oh, well, there are quite a few answers for my trivia question.
Oh, you have yes, because yes, there are 11 provisions that require approval by the people, and it's just, but you have at least one that you can say, okay, if I get this one right.
Okay, well, for example, we are unable to change our electoral process without a deeply entrenched referendum style.
Yes.
Yes.
And the very structure of the Constitution and that makeup.
The supremacy of the Constitution is another.
Yes. But thank you so much. I hope our listeners found the conversation to be as enlightening as we did. We really appreciate it. My name is Mikkel Jackson, Executive Director.
And I'm Jade Williams, Policy and Advocacy Specialist.
Have a blessed day.
Jamaicans, by justice, the people's champion. Justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Out of many we are one in a Jamaica. Make it a better place for the boys and and girls, created equal by the creator. For equal rights and opportunities, no to unlawful detention and police brutalization, class, gender, race or religion. We not tolerate discrimination.
To join the fight against injustice, contact us at 755-4524 or Jamaicans4Justice.org.
The people's champion.